The U.S. Supreme Court refused to stop a Texas abortion law from going into effect, but late Friday, a state court judge in Texas issued a temporary restraining order stopping a pro-life group from filing a lawsuit against Planned Parenthood in Texas. So this law, which was passed back in May, and it was going to just go into effect recently, what it says is basically you can't perform an abortion if you can detect a fetal heartbeat, which I believe is roughly around 6 weeks. Well, let's look at a little bit of the language straight from the law that was passed. This is Texas Law SB 8, and we're just going to pull it up. And this is under Section 171.203. A physician may not knowingly perform or induce an abortion on a pregnant woman unless the physician has determined, in accordance with this section, whether the woman's unborn child has a detectable fetal heartbeat. Now, one thing that's different about this law is it allows private citizens, so anyone living in Texas, they can file a lawsuit against an abortion provider or anyone who is suspected of aiding and abetting an abortion after that 6-week mark. And the law sets an award of $10,000 for any successful lawsuit to stop an abortion. So this law was clearly written to see if they could get Roe v. Wade overturned. Just as a reminder, so under Roe versus Wade and also under Casey, you can't prohibit abortions up until when the fetus is viable, which I believe is around the 22 to 24 week mark. And so this Texas law would take that down to like around the 6-week period. Just a quick note, so although this case was really decided on procedural grounds and the Supreme Court really just didn't grant this injunction, keep in mind that next term for the Supreme Court there is a case, Dobbs versus Jackson Women's Health Organization, and that is a direct challenge to Roe versus Wade, and so I think we will be seeing a decision coming down from the Supreme Court on that next term. So on July 13th, that's when the plaintiffs filed their lawsuit trying to challenge the constitutionality of SB 8. I'm going to simplify things a little bit just so we don't get caught in the weeds. But then on August 29th, the plaintiffs filed emergency motions with the Court of Appeals for the Fifth Circuit, asking the Fifth Circuit to issue an injunction along with some other things. And basically, I think it was the end of that very day that the Fifth Circuit just denied the plaintiffs' motions without any kind of explanation. Then August 30th, that is when they filed their application for injunctive relief with the United States Supreme Court. So September 1st, that's when we got the decision from the U.S. Supreme Court. Let's just take a quick look at it right now. You can see here Supreme Court of the United States, Whole Woman's Health versus Jackson on application for injunctive relief. The denial for relief was a 5-4 decision, and basically the majority said that there are some complex procedural issues that you basically haven't met your burden on, so we really can't make a decision yet. They did not decide anything substantively here. They did not overturn Roe versus Wade in this denial of application for relief. And it clearly states that. We're going to look at that language in a minute. But because this Texas law SB 8 had that kind of novel approach where they basically had private citizens being able to sue people who were providing abortions or aiding and abetting with that $10,000 reward, because of that kind of setup, the lawsuit had some procedural issues and complexity to it that they just didn't meet their burden in the U.S. Supreme Court's view, which is why they wouldn't grant them relief. Anyway, that's what they're talking about at the beginning of this quote. So let's just look at some of the language from this opinion. In light of such issues, we cannot say the applicants have met their burden to prevail in an injunction or stay application. In reaching this conclusion, we stress that we do not purport to resolve definitively any jurisdictional or substantive claim in the applicant's lawsuit. In particular, this order is not based on any conclusion about the constitutionality of Texas's law, and in no way limits other procedurally proper challenges to the Texas law, including in the Texas state courts. So very clearly, they did not overturn Roe versus Wade, and they did not decide anything substantively on this. Again, look at that language. We do not purport to resolve definitively any jurisdictional or substantive claim in the lawsuit. In particular, it's not based on any conclusion about the constitutionality of Texas's law. Okay, so it did not overturn Roe versus Wade. I've been seeing that all over social media, and it's driving me nuts because that is not what happened. And the Supreme Court has a case on the docket next term challenging Roe versus Wade, and it's this Dobbs case. That one you will want to watch and see what happens, and it's coming up next year, but this one didn't decide that. And Chief Justice Roberts, he joined the 3 liberal justices in dissenting from the denial of relief. Then, late Friday, a state court judge in Texas issued a temporary restraining order stopping a pro-life group from suing Planned Parenthood in Texas. So let's just pull up that. We'll take a brief look at that temporary restraining order. You can see this was in the District Court of Travis County, Texas. And let's just look at the specific language about the TRO. A temporary restraining order is entered enjoining defendants and any and all parties and persons in active concert and participation with them from instituting any private enforcement lawsuits against plaintiffs, their physicians, or staff under SB 8. This order does state that the temporary restraining order expires on September 17th, but I can easily see the judge extending that as the judge sees fit. And the judge also set a hearing date for September 13th. All right. Thanks for watching. We'll see you next time.